Okay, good morning, everyone. I hope you can all hear me.
We can hear you, sir. Good morning.
Yes, good morning. Welcome to
We can
yes,
use
yeah, good morning. Yeah, welcome to another week on the OVIP program. My name is Solomon Inimke. I'm a member of the IT team at Omaplex Law Firm. I believe the past few weeks in the internship program has been rewarding and impactful. I believe that because I heard some of the feedback you gave last week, and it was really, really commendable. And I think the program, the project is actually meeting its objective. So now, before we go into today's meeting or today's session, or before I go ahead to invite the guest speaker for today. I just want to give us a little heads up regarding the how the session is going to look like for today. So today we'll be having a breakout session at some point. I shared the scenarios last week with you guys, and I expected you've all gone through it. So there'll be a breakout session today. I expected you've all gone through the scenarios and you've prepped yourself for today's breakout session. Then, secondly, I just also want to reiterate the ground rules. We all know the ground rules, but I just want to reiterate it, and so we are all aware. So at some point, you are not found wanting at some point. So please, while the guest speaker or the moderator is speaking, kindly mute your mic and also mute your video. If you have any question, you kindly use the chat box. And if you also want to make any contributions, kindly use the raise your hand icon. Yes, so with that, so I just want us to also, yes, play a little game, something very, very different from what we did last week. The game is called How Well Do You Know the Law? So it's something similar to a charade, but this one, you're not demonstrating, but I'm just going to give you a hint on what it looks like. So it's how well do you know the law? So I'm going to give you a hint on the particular practice areas of law. And so I expect that as a fast thinker, you'll be able to depict what I'm talking about and tell me what area of law I'm talking about. So let me give you a typical example. So I want to talk about, let me say, unlawful termination of employment or workplace employment contracts, workplace harassment or violence. So I expect that you should be able to know that those areas, all those aspects I just mentioned, all those hints are talking about employment law. So I believe you guys understand what I'm saying.
Yes, sir.
Yes, okay. So let me just explain again. So it's something similar to charade, but now this one, I'm just giving you a hint in a particular area of law. So I made mention of employment law, for example. So I will mention some of the areas on employment law. Like I mentioned, unlawful termination of employment, employment contracts, workplace harassment or violence. So you should be able to know that I'm talking about employment law. So I want to go ahead now to start. So I want to, so if you have answers to the hints I'm giving right now, kindly use the raise your hand icon or use the chat box. So I'll pick it at random. So now let's start. So I'll expect that we will be as fast as much as possible. So I'll be calling out the fastest finger, the fastest finger. So now, okay, let's start. So I'm calling NFF Act, contracts with agents, contract between players and clubs. So which practice area has all those components? Okay, Maria Tevi, are up. Maria Tevi, are up.
Morning.
Sorry?
Sports law.
Sports law. Awesome. Awesome. The next one, we have AI, fintech, blockchain, IoTs. Oladiye Alex. Alex. Khadija, you're next.
Hello, sir. Hello, sir.
Yes.
Hello, good morning, sir.
Good morning. What area of law?
It's tech law.
Tech law. Okay.
It's tech law. Technology law.
Okay. Then we have unfair competition, confidential information, non-compete clause, breach of confidence. Nobody knows that one.
That should be competition.
IP law.
No, you don't do that. I'm supposed to call you before you speak. Okay, Nikita.
Yes, sir. I think it's IP law. Intellectual property right for confidentiality.
No, that's wrong. Okay, someone in the chat box got it. Thank God you got it. That's awesome. Then we have copyright, trademark, patent, trade secrets. Francis, you. IP.
Intellectual property.
Okay, okay, awesome. Now, so I have a few minutes. Now, I want Alex. So you unmute yourself and give us a hint and nominate someone to give us the answer. So you do that quickly as much as possible.
Hello, sir.
Yeah, so you give us a hint on
Sir,
a
please,
particular
I didn't
area
get
of-
your question.
Okay, something similar to what I just did. So you give us a hint and pick someone that is going to answer the question, or give us a hint and then I'll nominate someone that's going to give a response to that. Okay, if you are lost, Francis, you can. Yeah,
Okay.
up.
Okay, sir. Okay. Let me say.
Okay, go ahead. Okay. Francis, please, you're up. You have to be very, very fast and smart. Like, that's the idea.
I think I should. Okay. What if you're talking about patent, copyright, okay, let me go with another one. What of I actually don't know what to say.
Okay, Kinonso or Francis, or you guys missed it. Okay, then we have one Ndukwe. Yes, your answer.
Sir, can you hear me?
Yes, I can. Yes, go
Sir,
ahead.
can you hear me?
Yes, I can.
Okay. Defamation, passing of conspiracy.
Okay,
Defamation, passing of conspiracy, vicarious liability. So you can pick someone for me.
Okay, Kuro, you're up. Okay, Samuel Adeji.
That's thoughts law, law of thoughts.
Law of thoughts. Okay, is it correct?
Yes, that he's correct.
Awesome.
He's correct.
Okay, Samuel, do the same. Pick any area, give us the hint, and nominate someone.
No, you are supposed to come in and say, okay, you are wrong.
Okay.
Samuel,
Like,
okay.
okay. I can hear you.
Yes, please go ahead.
Okay, we have privity, offer, acceptance, consideration.
Okay, who has an answer to that? Okay, someone just mentioned it. Yes, we have some persons in the chat box. Ebere, Ekenobi, thank God, Mario Teobi. That's awesome. That's good. I like the energy, which means you guys have been following. You guys are actually studying law, and that's cool. So okay, so before we go, I go ahead to introduce the guest speaker for today. The guest speaker is
Intent legal relation.
Please kindly mute your mic. Yes, so without further ado, I would like to welcome the guest speaker for today's session. His name is Mr. Oriname Akeredolu. Sorry, Mr. Oriname. Mr. Oriname is a member of the IT, the dispute resolution team at Omaplex Law Firm with expertise in tax law, employment law, and labor law. His experiences in employment-related related dispute has given him several platforms to advise clients in multifarious transactions, such as extensive restructuring matters, headcount reduction, outsourcing arrangements, employment contracts, consultancy arrangements, executive compensation, termination of employment, and redundancy procedures. So I would like to welcome Mr. Oriname. Mr. Oriname, it's an honor to have you in today's session. We hope today's session is going to be very, very interactive and engaging as much as possible. So I would like us to give Mr. Oriname all the attention and audience he needs to ensure that we have a smooth sail today. Thank you, Mr. Oriname. Over to you, sir.
Good morning, everyone.
Good morning, sir.
Good morning, sir.
Good morning. I hope you've all been having a wonderful session all along from the day one till today. Today's topic for discussion will be on employment and labor law. I believe a large number of us have been involved in employment relationship, whether as an employer or as an employee. Probably as a sole trader, I believe this number will be on the higher side, especially with those that sell online and they call themselves CEOs. In the course of our conversation, I believe we'll get to understand the concepts of employment and labor law even more. This section will be divided into two. First, we'll be beginning with MCQs, and after that, we'll go into a breakout session where I expect us to discuss and come back to analyze the scenarios. When we get to the bridge, we'll cross it. Quickly, let's begin with our MCQs. I'll ask the question, I'll read the question out. If you know the answer, you simply put up your hand or comment in on the chat box, and the moderator will call you out. Are we clear on that?
Yes, sir.
Yes, sir.
Yeah.
All right, let's begin. Question 1. The final court for determination of labor-related issues on civil matters in Nigeria is Court of Appeal, National Industrial Court, Supreme Court, Apex Court, International Court of Justice.
Eke Neka.
Okay, good morning, sir.
Good morning.
It's A, Court of Appeal.
Beautiful. Question 2. Which of the following is not relevant to formation of contract of employment in Nigeria? Salary, agreement, intention to create legal relations, consideration, legality.
Matthew Okpara.
Salary.
Salary, are you sure? If you want to enter a contract of employment, would you consider the salary?
Salary.
Okay, that comes in as consideration.
Beautiful, beautiful, beautiful. This question borders on essential elements of a valid contract. And we all know that salary falls under consideration. Intention to create legal relations is also known as legality. So salary is the odd one there. There's agreement, which is divided into offer and acceptance, capacity, consideration, intentions to create legal relations. So salary is the odd one there. It's supposed to be consideration. Beautiful. Question 3. Question 3. Can an employer wake up on the wrong side of his bed and tell his employee, who is his house help, that he no longer needs her service orally without any notice, letter of termination, salary in lieu whatsoever, yes or no?
Kuro, you're next.
Yes, he can, because it's a contract at will.
Beautiful, beautiful. This is oral contract. An oral contract does not have any protection, any statutory protection. Yes, it is binding, yet it is recognized by law, but it's not having statutory protection. Contract at will, also known as oral contract. Thank you very much. Question 4, which is the last. Does an employer in the private sector need to give reasons before he terminates his employee under written contract of employment?
Samuel.
Yes or no?
Samuel. Deborah.
No, he doesn't give reasons.
Yeah. Good morning, sir. Yes, he has to give reasons for termination of his employee actually. So yes, the answer is yes.
Okay, Samuel, he said he doesn't have to give reasons. Can you explain further? Why does he not have to give reason? Don't you think it's fair that he gives reasons?
Okay, Francis.
Is this Francis? Okay, Francis. Francis, you answered earlier and you said he doesn't have to give reasons. I want to know your reason.
I was going to one, sir.
Okay. Okay. Well, actually, he has to give reasons. Since time immemorial, he doesn't have to give reasons. The law has it that he who has the right to hire can fire at will. That's the common law principle. However, with the recent National Industrial Court decision in Bello against Ecobank, the court said that before an employer can terminate the employee's relationship, it must provide reasons for this. Not just reasons, the reasons must be concrete and cogent before the court can hold it to be valid. The court relies on international best practices. Well, we hope to see what the appellate court will have to say about this decision. This decision, it has some a lot of considerations, a lot of uncertainties. So many scholars have come to appraise this decision. We wait to see the decision of the appellate court on this subject. But as it stands today, an employer must provide, employee must give reasons before he terminates his contract under written contract of employment. Are we clear on this? Now, moving on.
Yes, sir.
Moving on, we are going to the next segment of this discussion. There are three scenarios. Before now, I believe we've had the copies of these scenarios during the weekend. The social media administrator must have sent it to each and every one of us. So we are going to discuss these scenarios. How it will be done, there will be a breakout session where we'll all be divided into two groups of equal numbers. We'll go to our smaller groups, we'll discuss the questions and the answers. We appoint a representative to speak on your behalf. The representative cannot answer more than one question. So if, let's say, Khadijat answers question 1, Khadijat can no longer answer question 2 anymore. Khadijat can only answer one question. Are we clear on that?
Yes, sir.
Yes, sir.
Yes, sir. Yes, sir.
Beautiful. So let's go over to the scenario. I'll be reading the questions out so that when we go to our smaller groups, we just have to discuss the answer. I believe it will be faster that way. There are three scenarios. Scenario 1, Mr. Caleb is a wealthy farmer. He cultivates cocoa and cotton. He exports them to other countries, majorly in South America and Asia. He believes in hard work, even from a very young age. And for this reason, he opened a boutique for his daughter, Ezine, who is just 17 years old, to manage. He also instructed his son, Isaac, who is barely 13 years old and just completed his junior secondary education, to join his friend, Chief Oladipo, who runs a tech company, to learn software development, web design, amongst others. Mr. Caleb is married to a beautiful woman called Ene. Ene is a director in a food processing company. Because the company runs 24 hours in a day, her work schedule for the month of June is between 10 p.m. to 5 p.m. every day of the week. Now, there are 4 questions there. Group 1 will answer question 1 and 2. Group 2 will answer question 3 and 4. Group 1 will answer question 1 and 2. Group 2 will answer question 3 and 4. We'll get it clearer when we go to our different groups. After this session, we'll have a breakup. Please turn off your mic if you are not speaking. Turn off your mic, please. Scenario 2, a matter which borders on sexual harassment at workplace around New Haven, Enugu, was instituted in the High Court of Enugu State in 2005. Judgment was subsequently delivered in 2012 for the claimant, and damages were awarded accordingly against the defendant. The defendant, now appellant, dissatisfied with the judgment of the trial court, has filed an appeal before the Court of Appeal, Abuja Judicial Division, relying on Section 254C of the 1999 Constitution as amended, urging the Court of Appeal to overturn the judgment of the trial court for want of jurisdiction. There are 6 questions here. Group 1 will answer question 1, 2, and 3. Group 2 will answer question 4, 5, and 6. We move to scenario 3. 4 men who had been childhood friends are now in their mid-40s. They are all very successful in their various fields. Mr. Joe, a director of logistics and procurement at NNPC. Mr. Solomon, a medical doctor in a private hospital. Mr. Mike, a special assistant to the president. Please turn off your mic. Turn off your mic. Mr. Mike, a special assistant to the President of Nigeria on Information Technology, and Mr. Emmanuel, the legal practitioner, who is the principal in his private office. There are 4 questions here. Group 1 will answer question 1, 2, question 1 and 2, and group 2 will answer question 3 and 4. Are we clear on this? Are we clear on this?
Yes, sir.
Yes, yes, sir. Yes, sir.
Yes, sir. We're clear.
I want to break the rooms into 2 groups of equal numbers. You'll be requested to join. Kindly join the groups, group 1 and group 2. Thank you very much. Welcome back from that long break.
Thank you very much.
I hope we've all had a really productive discussions, and we've appointed our representative as well. I added extra 5 minutes just in case some of you want to complain that the time is not enough. So I believe with 20 minutes, we've had really productive conversations and we've tackled all the necessary questions. We'll be beginning with scenario 1. Representative from group 1, you will answer question 1 and question 2. Representative from group 2 will answer question 3 and 4. Question 1, what is wrong with NS employment? Representative from group 1, please.
Alex. Hello, sir.
Yes, Alex, I can hear you. Yes, I can hear you loud and clear.
Okay.
Alex, I think you're having... Alex, can you hear me? I'll suggest somebody else answer that question. Another representative from group 1, please tackle that question. Alex is having challenges. I can barely hear Alex.
Sorry, I'm from group. Damn, Lola is my name.
Okay.
What is wrong with NS employment?
Okay. There's nothing wrong with our employment because according to Section 55 of Labor Act, there would have been a problem if she was a manual worker, considering the time in which she goes to work. But she's in management. That means that there's nothing wrong with the employment. Beautiful.
Beautiful. I'm surprised you were able to fish out that section from the Labor Act. That's a beautiful answer. Another representative from group 1.
Hello, sir.
Would you answer if she was a nurse? Hello, Alex. I think you're having challenges with your network.
Yes, sir, but I think it's clear now. Can I speak now?
Yes, you can.
Okay, thank you, sir.
Alex,
my colleague rightly said, hello?
Alex, can you please turn on your video? If that's the challenge, don't worry. Just speak up. Alex, we cannot hear you. Alex, we cannot hear you. We cannot hear you. Another representative from group 1, please respond to question 2.
Hello, sir.
Hello, who's speaking, please? Your name and your group.
Akeredolu, representing group 1.
Okay.
Okay, my answer would be the same if she was a nurse. For the provision of Section 55 of the Labor Act states that women cannot work at night. However, there are exceptions, and nurses too are people who are exempted from that provision that women cannot work in the night. So she can.
So your answer will remain the same, whether or not she's a nurse?
Yes, sir.
Beautiful, beautiful. Group 1 did a thorough research. I hope Group 2 did the same. Group 2, discuss on the legal capacity of Izini and Isaac to work as an employee. Representative from Group 2, please.
Yeah, good morning, sir.
Good morning, Khadijat.
So I'll be discussing on the legal capacity of Izini and Isaac to work as an employee.
Okay.
So Izini would not be able, Izini's employment is wrong because she's still an infant, and an infant wouldn't be able to manage a boutique shop.
Okay.
And for Isaac, section is he can work there because he's an apprentice, and according to section 59 of the Labor Act, a child can be employed in as much as he's going to return home daily to his parents. And so far, the contract is not injurious to his physical and moral development.
Okay. Was it Khadijat? Did you make reference to, first of all, what provision of law did you use to justify that Izine is an infant, being 17 years of age?
According to the Child Rights Act, anybody under the age of 18 is an infant.
Beautiful. So the employment of Izine is invalid, but that of Isaac is valid. That's your point?
Yes, sir.
Have you made reference to Section 9 of the Labor Act? Okay.
I made reference to Section 59 of the Labor Act.
Have you made reference? Have you seen Section 9 of the Labor Act?
No, sir.
Okay. Your answer is correct for Isaac. However, for Izine, your answer is not exactly correct. The law is clear that when a specific provision governs a relationship, that position of law should be followed, and not the law that governs the general provisions. Child Rights Act, it's a general provision of law, but Labor Act is specific on employment relationship. So Labor Act will supersede over Child Rights Act, being that both of them are federal enactments. By the provision of Section 9 of the Labor Act, it puts a benchmark of the age as 16 years of age. So if you are younger than 16 years of age, you cannot validly enter into a contract of employment, 16 years of age. However, Izine is 17 years old. So Izine can validly manage the boutique of his father and being paid the fees, whether or not being paid the fees. She can validly enter into a contract of employment as a manager of a boutique, even at the age of 17. And Isaac's contract of employment, just as you pointed out, is to learn. The key word there is to learn as an apprentice. So it is valid because the exception under Section 9 of the Labor Act is an apprenticeship. So even if he's 5 years old, he can actually go into apprenticeship. Are we clear on that, Khadijat?
Yes, sir.
Well, it's a beautiful try, however. You have a question? I see you are unsettled.
No, I'm okay with it.
All right. Question 4. Representative from Group 2, please.
Good morning, sir.
Good morning. Your name and your group, please.
My name is Maria Toyebi. I'm representing Group 2 in regards to question 4. So the question is, Ene is pregnant now. How long should she go on leave in the absence of a maternity leave in the contract of employment? So according to sections 54 of the Labor Act, it states that a woman is entitled to, in cumulation, 12 weeks and 50% paid leave in regards to that. Then we also added the case of Okumbanwo and Group Consultants Nigerian Project Advisors. The defendant, essentially, she went on a maternity leave and it wasn't included in her term of employment, but the court ruled that she was entitled to do that because of the provisions that were in the sections 145 and 146 of the Labor Code Act as well. So she was entitled to 12 weeks leave of employment, regardless of the silence in a contract of employment.
Beautiful. I think you people did a thorough research. I'm quite impressed. I'm really impressed. We all know that in a situation where a contract of employment is made, it is binding on both the employer and the employee. Contract of employment includes all the rights, responsibilities, duties, obligations of both parties. However, where there are provisions that is left out, recourse is being made to the statute. What does the statute say? Maria Toibe, you did a beautiful work. It's 12 weeks maternity leave. However, you did not made mention that it's 6 weeks before delivery and 6 weeks after delivery. Probably it escaped you. We thank God for modern medical facilities that can detect almost with certainty the specific day a woman is expected to put to bed. So she can go on 6 weeks before delivery and 6 weeks after delivery. Are we clear on that, group 2?
Yes,
clear on that?
Yes, sir, we are clear.
Move over to scenario 2. Before we move over to scenario 2, this question 4 is actually a true life scenario a true life case, a real life case that I participated in some 3-4 years back. One of the very first files that I handled in this law firm. There was no provision, there was no clear provision in the contract of employment. So we made recourse to the Labor Act and the court held that it is valid. So moving on to scenario 2. The first 3 questions are to be answered by group 1. What is the provision of section 254C from the 1999 Constitution?
Good morning.
Legal issues. I'm coming. Allow me to talk, please. I'll call on you. Does the High Court of Enugu State have the proper jurisdiction to entertain this suit? Now, representative from group 1, I will expect new faces. I don't want the same face that answered scenario 1. New faces. So representative from group 1, please. Question number 1. Your name and your group.
Good morning.
Good morning.
I'm Francis. I'm from group
Francis.
I'm Francis from group 1. And
here you are, is a big noise, Mr. Francis.
Yeah, so according to the section 254, it states that notwithstanding the provision of section 251, 257, and 272, and anything contained in the Constitution, and in addition to such other jurisdiction as will be conferred upon.
Francis, hold on. You turned off your video so you can read from the Constitution.
No, my video is on.
I couldn't see you. You don't read. You don't answer the question from reading from a sheet. This scenario was sent to me since Friday last week. I believe that's enough time for you to. You don't have to tell me word to word. Just tell me the key provisions of Section 254C as it relates to this scenario. I'm not asking you to give me the full citation of everything in 254C. Just give me the key issues as it relates to this scenario. Mr. Francis, are we clear?
Okay, sir. Can you listen? Are you listening, sir?
I'm hearing you loud and clear.
I'm coming, sir. I'm to switch on my video, sir. Majorly, the section 254 is just stating, it's just actually providing the jurisdiction for the labor court, sir. Hello, sir.
I'm hearing you.
So majorly, it's just telling us the jurisdiction, the civil jurisdiction of the National Industrial Court of Nigeria.
Okay.
Yes, sir.
Beautiful. Not necessarily the civil jurisdiction alone. If you look at section 254C, subsection 5, it also provides for the criminal jurisdiction. So it provides for the jurisdiction of the National Industrial Court. It places the National Industrial Court as the superior court of record, as the exclusive court to entertain civil causes and matters. So all civil causes and matters are now within the purview of the National Industrial Court alone. This is the provision of section 254C as it relates to this question. Olajide Alex, I see your hand is up.
Yes, sir. Sorry, sir, I was having network issues. I wanted to state the provision of section 254C, paragraph, sub 1, paragraph G, which relates to matters connected with
harassment.
Hello, sir.
I'm hearing you. Which relates to matter connected with sexual harassment, yeah?
Yes, sir, yes, sir.
Beautiful.
That's what I wanted to say.
Beautiful. That's key. Thank you for reminding me. That's really key to this scenario, because this scenario is majorly on sexual harassment. Thank you very much. Identify the legal issues. Yes, I can hear
please,
you.
I want to point out some observations. Please, to the participants, before you make any contributions, kindly ensure that you are in a serene environment before making contributions. I notice some persons are having background noise, and it's not nice at all. So please ensure before you speak, ensure you are in a place that is quiet. Thank you. Please go ahead.
Thank you, Mr. Solomon, for that intervention. Thank you very much. Another representative from Group 1, please. Identify the legal issues in this scenario. A representative from Group 1. I was thinking we've appointed representatives already during the course of our breakout session. I was expecting that we've appointed representatives in all the scenarios. Why are we having blackouts? Eke Nika, your hand is up.
Hello, sir. Can you hear me?
Yes, you've spoken before, yeah?
Yeah, we had a representative. I don't know.
Who was your representative?
So, I've forgotten the name of the person, but we appointed someone.
You've spoken before. Let's give the floor to somebody else, please. Brilliant.
Okay.
Good morning, sir.
Good morning, Mr. Brilliant.
One of the issues in this scenario is whether the Enugu State High Court has jurisdiction to entertain the suit.
That's one of the legal issues. What are other issues? Turn off your mic, please, if you are not speaking. Okay, I will answer this. The legal issues here is the subject matter, which is sexual harassment. As Mr. Alex has pointed out, is provided for in section 254C of the Constitution. 254C, subsection 1, paragraph G. The jurisdiction of the State High Court to entertain the suits. The jurisdiction of the Court of Appeal to hear the appeal. And also the year that the judgment was delivered at the trial court, 2012, and the year the matter was instituted, 2005. These are the 5 legal issues in this scenario. Question number 3. I hope we have a representative for this question. Deborah Marshall, your hand is up.
Yeah, good morning, sir. Am I audible?
You're very audible.
Okay, thank you very much, sir. Okay, so question number 3. Does the High Court of Enugu State have the proper jurisdiction to entertain this suit? No, the High Court of Enugu State does not have the proper jurisdiction to entertain this suit. And I'm basing my answer on the following provisions and a case. I'll go with the case first of all. Okay, so in the case of AGK Maduka versus Microsoft and us, the National Industrial Court of Nigeria was for the first time handed the opportunity to declare a strong stance against workplace sexual harassment. And also by the provisions of section 254, subsection 1A of the 1999 Constitution, it confers exclusive original civil jurisdiction on the National Industrial Court over civil causes and matters relating to or connected with any labor, employment, trade union matters arising from workplace. And subsection 5, like you said, also confers criminal jurisdictions on it. When it comes down to issues as regards fundamental human rights, sexual harassment, the National Industrial Court has the original jurisdiction to handle this issue as far as it's related to workplace. If these issues are like this issue as regards sexual harassment did arise from the workplace, the court which has the original jurisdiction to handle this problem is the National Industrial Court. So the High Court of Enugu State in this scenario does not have the proper jurisdiction to handle it. It should have been taken to the National Industrial Court. Thank you, sir.
Beautiful, beautiful. You were well detailed, and it's comprehensive, and you did a thorough breakdown. However, does anyone have a contrary opinion to that answer before I speak? Brilliant Ozilo, your hand is up. Do you have a contrary opinion?
No, I do not have a contrary opinion. I just want to add that the case was instituted in 2005 when the State High Court had jurisdiction over employment matters.
Where you are is really noisy. Where you are is really noisy. Please turn off your mic. The moderator has mentioned it earlier. Please turn off your mic.
Oh, okay, sir.
Before you speak, please ensure you are in a serene environment, okay? Before you speak, ensure you're in a serene environment. Turn on your mic, turn on your video, then you speak. I will intervene now. I will answer the question for want of time. The High Court of Enugu State has proper jurisdiction to entertain this suit. Are you surprised? Yes, the National Industrial Court, as at 2005, does not have the exclusive jurisdiction to hear this suit. I mentioned that the fifth legal issue is the date. The year rather, that the matter was instituted and the year judgment was delivered. I mentioned this earlier. As of 2005, the National Industrial Court does not have the exclusive jurisdiction to hear this suit. Let me give a brief summary of National Industrial Court, a brief history rather. National Industrial Court was established in 1976 by virtue of Trade Dispute Act. That's like 45 years ago. It was not a superior court of record when it was established. It was only a court that hears trade disputes, and enforcing this judgment is really difficult. If judgment is given, the party that won the judgment will still file a fresh matter in the High Court, not for enforcement, but initiating a fresh procedure, attaching the processes of the attaching the judgments given by the National Industrial. Enforcing this judgment was really tasky. However, in 2006, it was elevated to the status of a superior court of record, still by the Trade Dispute Act. But yet, it did not have exclusive jurisdiction. It was only in 2011, by virtue of the Third Alteration Act, Section 254C, subsection 1, paragraph G, that provides that National Industrial Court shall have exclusive jurisdiction to all other courts in civil causes and matters. And G made mention of sexual harassment. So as of 2005, the High Court of the state can hear the matter. Even in 2010, just before the Third Alteration Act was enacted, the state high courts have proper jurisdiction to hear, entertain, and determine the suit. Are we clear on that? Are we clear on that? Comment on the chat box.
Yes, sir, we are clear on it.
Beautiful. Any further question on this? Moving on, we'll go over to question 4. Question 4, 5, and 6 will be answered by group 2. I see that somebody's hand was up earlier. Somebody's hand was up earlier. All right. Question 4, 5, and 6 to be answered by group 2. Do you have your representatives here? Please respond to the question. Question 4, 5,
yes,
and 6. Starting from question 4. What is forum
shopping? Good morning,
sir.
I'm Ogunpit Onjolade. I'll be representing
your name and where you are.
My name is Ogunpit Onjolade, and I'll be representing group 2. I'll be answering the question on that scenario 2, question 4. What is forum shopping? Forum shopping refers to like the practice of choosing the court or the jurisdiction that has the most favorable rules or laws that for the position that is being advocated. And this mostly happens when we have like one or more courts that has jurisdiction over the disputes. So then forum shopping comes in, that they have to like pick the court that has the most advantage for the case being advocated. Hello? Hello? Did you hear me?
I can hear you.
Did you hear the
Tell her
answer
there,
again, sir?
I think the facilitator is down for now.
I think the
Can we all
network is
hear
a
me?
break in. Yes, we can hear you now. Echo
Sorry
back, sir.
for the technical glitch.
Sir, should I
Apologies
take
for
the
the
answer
technical
again?
glitch. Yes, somebody was speaking earlier.
Yes, I said my name is
Introduce yourself
Jolade, and I'll be
your
representing
group.
Group 2, and I'll be answering the question, what is forum shopping? So I said forum shopping refers to the practice of choosing the court or the jurisdiction that has like the most favorable rules or laws for the position that is being advocated. And I said this mostly occurs when we have like two or more courts that has like jurisdiction. When we have more than one court that
The
has
connection is
jurisdiction.
terrible. I can barely hear you. Can somebody else speak? Can somebody else intervene for group 2? I can barely hear you.
Hello, can you hear me now?
Question 2.
Hello,
Group
can you
2,
hear me now?
question 3. Question 4, sorry.
Hello?
I think you have problem with your network. Are you sure you can still speak? I will suggest somebody else
Yes.
from your group speaks.
Okay. Maybe I should try one more. Hello, can you hear me clearly now? Hello?
We can hear you very clear.
Can the facilitator hear me?
Hello, I can hear you.
Okay. Forum shopping, I said it refers to like the practice of choosing the court or the jurisdiction that has the most favorable rules or laws for the position that is being advocated. And I said this mostly occurs when we have more than one court that has the jurisdiction over the dispute.
Sorry, can you come over again? We were having technical glitch.
Okay. I said forum
Sorry
shopping.
about that. Apologies.
Okay, sir, can you hear me now?
Can you please come over again?
Can you hear me now, sir? Hello, can you hear me now?
You are audible.
Hello?
Yes, please, can you turn off your mic?
Hello?
Abdul, can you turn off your mic, please? Dagbo Abdul Rahman, can you mute your mic?
Muted.
Thank you. So sorry about that. I think the moderator was off at some point. So while we're waiting for the moderator to come back, please, I just want to lay emphasis on what I've said earlier. Before you speak or while the session is going on, I recommend you always choose a location that is quiet. We don't want any interference while you are speaking, because I noticed a lot of persons were a noisy place. So please, before you ensure you speak or while the session is going on, ensure you pick a quiet or a calm location where you can speak comfortably well without interference from the background. I hope this is understood. I don't want this to repeat itself again. I think I've noticed this over time. So I'll ensure that I recommend before you join the meeting or the session, choose a location that is without noise or a calm or quiet place in your house or in your office or in the school, wherever you are, before joining the meeting, please. Thank you. I hope that is understood.
Yes, sir.
Okay, thank you so much. Yeah, so while we are waiting for the moderator to join the session, I need two feedback from two people, like what you've learned so far, judging from this scenario and also from the scenario so far. Also, what can you say about the session? Two takeaways. Yes, Deborah, you're up.
Yes, sir. I think my biggest takeaway right now will be taking account to the year and date and exactly knowing when a case was being instituted, to really know the jurisdiction of a court, and also getting to understand the privileges as regards a pregnant woman who is in running her course of employment, and the leave in which she has, the 6 weeks and the 6 weeks before her due date and the 6 weeks after her due date, and the provisions of the Labor Act as regards even the hours of work. And apart from that, the provisions of the Constitution, like Section 254, we really looked into it, and then we understood the original jurisdictions of the National Industrial Court. And then we got to understand the fact that we have to take into account our years and our dates and look really closely into the facts to be able to understand properly when a case was being instituted. So that would be my biggest takeaway now. Thanks, sir.
Wow, that's brilliant. That's brilliant. So I will also recommend before you speak, ensure you make your contribution as brief and concise as much as possible. Thank you. Samuel, you're up.
All right, thank you so much. Just to add to what previous speaker has spoken relating to the jurisdiction of the state high courts and the national industrial courts. And before now, I used to think that since when I went through that scenario, I always felt that the state high courts of Enugu State had jurisdiction to entertain the matter, given that the subject matter was criminal in nature, and then state high court has a lot of criminal jurisdiction as far as criminal issues are concerned. But when our facilitator was talking about the dates and all, I now got to realize that as far as workplace sexual harassment is concerned, the National Industrial Court has jurisdiction, exclusive jurisdiction to entertain the matter. And secondly, the issue of termination of employment without notice. You know, from this session, I've taken out that before now, the position used to be that
Samuel,
an employer
we can't hear you. Samuel, I think the facilitator is up. Maybe I can take your contributions after the session. Mr. Samuel, you can mute your mic. Thank you. Mr. Oriname, can you hear me, please? Okay, I think while you're waiting for Mr. Oriname to come back up, I will move on to the next person, which is Akeredolu. Hurry up, as brief as much as possible.
Okay, can you hear me, sir?
Yes, I can hear you, Nika, please. Go ahead.
Okay, my takeaway so far from this session is on termination of employment. I've learned today that before you terminate, it's necessary to give reasons for termination. And also, if a woman is employed and she occupies a key position in the company, she can work at night. So these are my two takeaways so far.
Okay, that's fine. Brilliant. Then I think the last person is Nikita. Yes.
Yes, sir. Hello, am I
Yes.
audible?
So what's the key takeaway?
Yes, sir.
Go ahead.
So, sir, being an Indian law student and having the knowledge of Indian jurisdiction, this session has been helpful for me to realize that how the jurisdiction is divided in Nigeria and how important they are considering the women's employment at night shift or their working condition, they are pregnant or not, is there any maternity leave, and the types of employment. This session has been very helpful for me, and the productive session of breakout was very good. It wasn't that much audible, but still it was very, 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 very good. Thank you.
Okay, Nikita, thank you so much. Well, I can hear you. Okay, that's fine. Mr. Oriname, over to you. I hope you're available, sir. Mr. Oriname? Okay, I think I'll take one more contribution while I check on Mr. Then Isaac or Israel, sorry.
Yes. Good morning. Can you hear me?
Yes, good morning. Yes, I can hear you, Israel.
Yes. So my biggest takeaway from today's session was actually not the fact that litigation, when it comes to labor-related matters, ends at the Court of Appeal and not at the Supreme Court. That's my biggest takeaway from today's session.
Okay, that's brilliant. Khadija, over to you.
Sir, I was
You're up
audible.
next.
Sorry. Was I audible? Hello, sir. Hello.
No, Nikita.
Yeah, good morning, sir.
Yeah, I wanted to ask, was my answer audible?
Yes, good morning.
So my biggest takeaway from today's section is the fact that an infant underneath the age of 16 can actually manage a business according to Section 9 of the Labour Act.
Okay, awesome.
And
then
that
okay. Go ahead.
And I also need to pay attention to the date the case was filed, the laws that were relevant at that particular period, because the law changes over time. So I have to pay attention to that also.
Yeah, that's cool. Yes, Olajide Alex, over to you.
Okay, sir. My takeaway from today's section is the nature of infants, that is infant employment under the Labour Act. The Act provides that, except in the case of contracts of apprenticeship, that is training, that no person under the age of 16 shall be capable of entering into a contract of employment, that a person under the age of 15 cannot be employed or work in any industrial undertaking unless it is for his or her training. So that is what, according to section 59 sub 2 of the Act.
Okay, brilliant. Then Koro, you're up next. Kuro, you're up next. Okay, Nikita, over to you.
Yes, sir. I wanted to ask, was I audible earlier when I answered the question? Hello?
Yes, you can go ahead, please.
Sir, I wanted to ask, was I audible earlier when I gave the answer about the session?
I can barely hear you.
Hello.
Please.
Am I audible
Yes,
now?
I can hear you. Yes, go ahead, please.
Sir, I wanted to ask, when I answered the question earlier, was I audible?
Yes, you were at some point, but you went off. So, but if you have any further questions, you can kindly drop it on the chat box.
Okay, sir. Okay, can I repeat the question? Repeat the answer of the brief?
Hello, everyone. Can we all hear us?
Yes, Mr. Oriname. Yes, Mr. Oriname is back up. Yes, sir. Yes, we can.
My sincere apologies for that technical glitch. I really apologize for that. We were tackling question number 4 earlier before I went off. The representative from group 2 was trying to explain what she understood by forum shopping. Can we continue that conversation?
Hello, sir. Good morning, sir. Can you hear me now, sir?
Your name and I can hear you very clearly. Your name and your group.
Yeah, my name is Ogunput Onjolade, and I'm representing Group 2. So I'll be giving the definition for forum shopping. I said earlier that forum shopping refers to the practice of choosing the court or the jurisdiction that has the most favorable rules or the laws for the position that is being advocated. And I said this mostly occurs when we have more than one court that has the jurisdiction over a matter. So when we have more than one court that has a jurisdiction over a matter, then there's space for forum shopping. That is, there's space for the maybe lawyer, whoever is instituting the action, to choose the court that has the most favorable law for their case.
Okay, that's a beautiful response, Jolade. However, it's not entirely correct. Forum shopping is not choosing a court that has most favorable jurisdiction. What did you say? You can choose for you can decide to institute a matter in a court for different reasons. For selfish reasons, particularly, probably the judge is a primary school classmate. Probably you are friends with the registrars. Probably it's closer to you. Probably just if you are not speaking, please turn off your audio. Turn off your mic. Probably it can be sheer wickedness because you want to punish the defendant. You want the defendant to be traveling. The person instituted the matter, plaintiff, claimant, appellant, applicant, however name is being described. Now, institute the matter in a different court for a selfish reason. And this court does not have the jurisdiction to entertain the matter because of the geographical location it is situated. Now, the court has over time frowned against this practice of law, and some courts are not, it cannot be said that you forum shop in some courts, and that leads us to question number 4. Does instituting the appeal at the Court of Appeal, Abuja Judicial Division, amounts to forum shopping? Still on forum shopping, question 4. There was something you made mention of here. You said, especially when more than one court has the jurisdiction to entertain the matter. That's not entirely correct as well. From shopping is when you institute the matter in a different division. It's still the courts. It's still the same court, but a different division. Let's say High Court of Enugu State. The cause of action arose in Enugu State. You now instituted the matter in High Court of Lagos State. It's the same courts. It's not different jurisdiction. It's the same court with the same jurisdiction, but however, with different division. Are we clear on that? Are we clear on that?
Yes, sir.
Yes, sir.
We're clear on that, sir.
I see your hand up, Kuru and Deborah Masha. Kuru, let me hear what you have to say.
Yes, prior to this time, I've not really grasped as to the meaning of forum shopping. I was thinking maybe it has to do with appealing to the gallery, like in the court. I don't know if that also falls into what forum shopping talks about.
Beautiful question. The answer is simply no. Forum shopping does not amount to appealing to the gallery. Forum shopping is simply a situation where the person instituting the matter in court brings the matter in a different judicial division from where the cause of action arose. Simply put, in the simplest form, that is forum shopping, where an individual instituting a matter in court brings the matter in a different division from where the cause of action arose. Deborah Masha.
Sir, like I have a question as regards that different division. Is it not more preferable that you bring an action like where the case arose, like the location? Like, why would a case happen in Kano State? And you know that the courts in which has such division and jurisdiction to hear the matter is like the High Court of Kano State. And then you leave Kano State and you're going to Lagos State High Court. Like, is it actually okay to do that? Like, is it preferable to do that when you know that the issue arose in Kano? So why then are you going to, let me not even use Kano because of the whole penal code. Let's say, okay, it happened in Osun State. So why are you going to Lagos High Court? Why don't you just go to the High Court in Osun State? That's my question though.
Beautiful question. That your question is simply forum shopping. That's what we are discussing about. If a cause of action arises in let's say, Kano, okay, the Osun State, you can only institute that matter in Osun State. When you now go to Lagos, because they are courts of the same jurisdiction, when you now go to Lagos State High Court to institute the matter, you are now forum shopping. The court has frowned against this several times. Depending on the rules of the court, what it's usually done is either striking out this matter for want of jurisdiction or transferring the matter to an appropriate court. Your question is simply forum shopping, and that's what we are discussing. Are we clear on that, Deborah Marshall?
Yeah, I'm clear on it. So is forum shopping illegal? Like, is this something acceptable? Is it something
It is not acceptable. It is not acceptable. The court will either strike the matter out or transfer it to the court with the appropriate jurisdiction, depending on the rules of the court. It is not proper. The court has several times frowned against it.
Yeah, that's true. Thank you, sir.
Are
Thank you very much.
That, Deborah Marshall?
Yes, I am. Thank you very much.
Nikita Soni, your hand is up.
Sorry, sir. I left it by mistake. I was answering Solomon's question. So sorry.
All right. Question 5. Does instituting the appeal at the Court of Appeal Abuja Judicial Division amounts to forum shopping? Somebody from Group 2, a representative from Group 2 that has not spoken before.
Yes. Good morning, sir.
Good morning, Israel.
Yes, sir. So, based on all submissions that we had, yes, instituting the action in the Court of Appeal Abuja Judicial Division would amount to forum shopping, since the cause of action was took place in Enugu, and Enugu State actually has the Court of Appeal Judicial Division. So I believe that going ahead to institute that cause of that appeal at the Abuja Court of Appeal Judicial Division would amount to forum shopping.
Beautiful answer. Any contrary answer? Do we have any contrary answer? Okay, I believe, sorry, I was reading the comment section. I believe that's the position that we've agreed on. However, that position is not correct. Instituting the appeal in the Court of Appeal, Abuja Judicial Division, does not amount to forum shopping. There are 3 courts that it cannot be said for a party to have forum shop. These are the Supreme Court. It's very clear for Supreme Court because there's just one Supreme Court in the whole of the Federation. So you cannot bring a matter from a different jurisdiction to a Supreme Court, because the Supreme Court has a nationwide coverage. So that position is clear. The Court of Appeal as well. The Court of Appeal has different judicial division for administrative purposes and convenience. The court has even gone further to say, if a court of appeal, let's say Lagos Judicial Division, is hearing your matter, the matter has already commenced. The matter is already ongoing. You can go to another court of appeal, let's say Abuja Judicial Division, and file your processes in the registry of Court of Appeal Abuja Judicial Division. If the registry accepts your processes, it is deemed to have been properly filed. It is deemed to have been properly filed. The registry now knows the arrangement they will make between Court of Appeal Abuja and Court of Appeal Lagos. You cannot forum shop also in Federal High Court. The court has one jurisdiction, however, with different judicial division for administrative purposes and convenience. This is by practice and procedure, and by the rules of the courts, by judgments of the courts as well. Moving on. In a situation where judgment was given in the Court of Appeal against the appellant, does he also have the right to appeal to the Supreme Court, a representative from Group 2? Group 2, please. Ojo Emmanuel, your hand is up. Ojo Emmanuel, your hand is up. I believe you want to say something.
Yes, sir. Yes, sir. I was just logged out. Network issues. So okay. I am Group 2 and I'm to answer question 6, scenario 2. So I don't know if I'm able to. I was able to. Yeah.
All right. We are waiting for you. You are listening.
So is it time to answer the question, sir?
Yes, it is. I just read out the question again. In a situation where judgment was given in the Court of Appeal against the appellant, does he also have the right to appeal to the Supreme Court?
Yes, sir. In this question, the answer to the question is that the Supreme Court does not have jurisdiction. The final court of jurisdiction as regards labor matters is the Court of Appeal. In a case of Ms. Akinsoya versus Coca-Cola. So the Supreme Court will state the fact that any labor matters as regards employment, except if the matter is taken out of any labor issue at all, the final court of jurisdiction still remains the Court of Appeal, and it will be the final court of appeal.
Beautiful answer. Do you have a contrary opinion? Kuro, your hand is up.
So I have a question. Okay. Can I go on?
Who's speaking, please?
Deborah Marshall, I have a question.
Hello?
Yes. Sir, part of the court that you cannot actually is the National Industrial Court part.
Okay. The National Industrial Court, yes, we all know that it's just one National Industrial Court with different judicial divisions for administrative purposes. However, this forum shopping is not a written law. Are we understanding me? It's case law. By interpreting the laws, the judges have come up with the term forum shopping. It's not stated anywhere in any law. The court is, however, yet to pronounce on whether the National Industrial Court, whether you can forum shop in the National Industrial Court. The court has only pronounced on the Supreme Court, the Court of Appeal, and the Federal High Court. The court is yet to pronounce on the National Industrial Court, so it is dicey. This is, however, not clear yet. There's still so much uncertainty as to this position of law. But to my mind, if you cannot forum shop in the Federal High Court, you cannot also forum shop in the National Industrial Court. You can only forum shop in the High Court. As in a superior court, you can only forum shop in the High Court. To my mind. But let's await the decision of the courts as it relates to forum shopping in the National Industrial Court.
Thank you, sir.
Kuro, your hand is up. You have a contrary opinion about the last
I believe the Supreme Court, the matter can be appealed up to the Supreme Court because it's a fundamental rights case. I think that's one amongst the two exceptions where such appeal can go further.
Okay. Adewala Quadri, what do you have?
Good morning, sir.
Good morning, sir. So I also follow what my brother just said now. I feel the Supreme Court should have jurisdiction for appeal from the Court of Appeal, because aside from issue of workplace, this is a criminal matter, issue bordering on sexual harassment, and by section 233(2), I guess, it allows appeal to come from the Court of Appeal bordering on civil and criminal matter. So I think even notwithstanding that it's in a working place and it borders on employment, it's still
Sorry, we lost you, Adewala Quadri.
Thank you, sir.
Beautiful answer. Okay. Please, for want of time, we won't be taking much questions anymore. Beautiful answer, Adewala Quadri, and your previous intern that spoke before you. The answer is, the position of law rather is that you can institute the matter even up to the Supreme Court. However, it's not because it's a fundamental right issue. It borders on sexual harassment. It wasn't stated that the appellant, or rather the claimant, instituted a fundamental rights proceedings. He instituted a sexual harassment proceedings in court. So it's a civil matter under section, or rather it's a criminal matter under section 254C1G, but it's exclusively for the National Industrial Court. However, because of its criminal nature, it's exclusive for the only the National Industrial Court can entertain it. However, because of its criminal nature, appeal can be taken to the Supreme Court. 243 sub 4 mentioned that only the Court of Appeal can hear civil causes and matter, and it is the final court for the determination in civil causes and matter. But in a situation where it is criminal, the Supreme Court can hear, entertain, and determine the suit. Are we clear on this position?
Yes, sir.
Beautiful. Now, wrapping up, we are going over to scenario 3, which is the last scenario. As I said earlier, group 1 will answer question 1 and 2. Group 2 will answer question 3 and 4. Very quickly, please. Kindly identify the types of employment. Representative from group 1. I was thinking that during the course of our breakout session, we've already appointed representative to speak. I'm really surprised that it takes a really long time before someone indicates interest that he is the representative to answer the question.
Hello, sir.
Suni,
Nikita, sir, because of less time, the group has discussed only 2 scenarios, so I covered the 3rd scenario. So should I start?
Okay.
So I think there are 3 types of employment. Employment governed by statute, employment governed by written contract of employment, and employment by the will of employer. And the identified as Mr. Mike is governed by statute employment. Mr. Solomon and Mr. Joey is under employment by written contract, and Mr. Emmanuel is under employer by will. And I have dealt with the question number 2 also, if I can proceed.
How about Mr. Mike? You didn't mention Mr. Mike.
Yes, sir. Mr. Mike is under employment governed by statute.
Okay, beautiful. Does anyone have a contrary opinion? Kuru, your hand is up.
Okay.
Yeah, I think Mr. Mike his employment is under employment at will.
Okay.
Excuse me, sir. I would also like to say Mr. Joe doesn't seem to be employment under statute, despite the fact that NNPC is a federal subsidiary.
Okay.
That I think it's employment on under contract.
Okay. What's your reason? You have a particular reason?
I don't know. It just doesn't sound well that is governed by
Well,
statute.
Mr.
thought
Joe's employment is governed by statute. He's a director at NNPC. NNPC provides for the modes of employment and also the modes of termination of their staff. It's strictly governed by statute. Solomon, a medical doctor, is governed by written contract of employment. I'm glad nobody has disputes as to that. Special assistant to the president, there's a high likelihood that it's not governed by statute. It's oral form of employment, employment by will. And Emmanuel, who is a legal practitioner, he performs his employment as a contract for service and not a contract of service. So it doesn't fall under the three categories of employment here. Emmanuel performs his contract as performs his employment as a contract for service. When he's being hired, let's say he has clients, he has like 30, 40 clients. He performs his duties as a contract for service. He's not under their employment. He's not an employee of his staff. Listen, he's the principal of his office. So he's not working under anybody. Any contract he's performing is based on contract for service. Members of Group 2, any representative to answer question 2? What are the modes of terminating same? I see your comments, thank God. Yes, the contract is at the pleasure of the president. The president can wake up tomorrow and say, the contract is over, it's being terminated. It's not backed up by any law or statutes. Representative to answer question 2 from Group 1. Nikita Soni, you've spoken before. You can't speak more than once. Angela Victor.
Good morning, sir. I'll be answering question 2, sir.
Okay.
The mode of terminating a contract that is procured under the statute is by following the provisions of termination as contained in the statute. So if Mr. Joe's employment with NNPC will be terminated, it has to be in accordance with the provisions of termination in the statute that created the NNPC. See the case of Alaniyo against the University of Lagos. And Mr. Solomon, a medical director in private practice, the mode of termination would be as contained in the letter of employment, or it can be terminated at will by the employer. Either way, if he's terminated wrongfully, like if there is a provision in the letter of employment that contains how the employment will be terminated and it's not followed by the employer, then he's entitled to compensation. Though the court would not, even if he sues for wrongful dismissal, the court would only compensate him. The court would be reluctant to impose a willing employee on an unwilling employer. Okay, for Mr. Mike's employment is at will, because the president can decide that he does not need the service as a special assistant anytime, any day. And so, except where Mr. Mike has, except where in the letter of appointment as a special assistant to the president, there contains a provision as to how he would be terminated. And I don't think there will be there. So the president can wake up to dismiss him anytime, any day. The exception to this is that he would have to, the court might order that is to be paid in lieu, paid salary in lieu for that termination without notice, because there is a provision by law that I think in the Labor Act, I've forgotten the section now, that there has to be termination. If there's to be termination of contract of employment, there should be notice, and there's a minimum basis for that. So where the employer is not giving notice, then the employer would have to pay in lieu of notice. And Mr. Emmanuel cannot be dismissed from work since is the principal partner of his firm. However, if any contract, because he performs contract for services, if the contract is to be terminated, then it will just be between him and the client, pertaining to just one contract between them. Since he's not been employed by any of the clients. So it cannot be dismissed. Thank you very much, sir.
Thumbs up, Ayila Victor. That's a beautiful answer. I really do not have anything to contribute anymore. You've clarified everything. And that's the position of the law. Exactly how you have stated it. That's the position of the law. Thank you very much, Ayila Victor. Moving on,
thank you very much, sir.
Somebody from group 2, help us distinguish between contract of service and contract for service.
Okay, hello, sir. Hello.
Hello, Oluwatobiloba.
Yes, sir. I'm answering question 3 for group 2.
Okay.
So a contract of service is an agreement whereby a person employs another person as an employee, and where the employee now agrees to serve such employer as his employee.
Oluwatobiloba, are you sure you're not reading from a book? Your video
I'm not
is
reading,
off.
sir.
The way you are sounding, I want to think you are reading from a book.
I'm not reading, sir. I don't know if my video is showing now.
It's clear now.
Okay. So a contract of service is an agreement whereby a person agrees to employ another person as his employee, and such the employee now agrees to serve that employer as his employee. So it's more of saying like an employee-employer relationship. That's for contract of service. While contract for service is whereby a person agrees to engage the services of another person, or an independent contractor or independent person. So it's more of saying like engaging the services of a self-employed person or self-employed contractor. So relating it to the scenario, Mr. Joe, for Mr. Joe, it would be a contract of service, considering the fact that Mr. Joe, the relationship between Mr. Joe and NMPC is an employee-employer relationship. And while for Mr. Solomon, it will be a contract of services, as Mr. Solomon is a medical doctor and there is an employee-employer relationship between him and the hospital. Also for Mr. Mike too, it will be a contract of service. While for Mr. Emmanuel is a self-employed person, so it will be a contract for service. Thank you, sir.
Beautiful. That's a beautiful distinction between one from the other. And the last question for today, what are the tests to easily distinguish one from another? That's contract of service and contract for service. How do you distinguish? What's the clear-cut line to say, okay, this is contract for service and contract of service? Olise Judith Jade.
Hello, sir. Hello, good morning, sir.
Good morning.
Can you hear me?
Yes, I can hear
Hello.
you. Hello, I can hear you.
Just flowing from the distinction that Oluwatobiloba had drawn up, there are tests that distinguish one from another. One of the tests will be the test for control and the test for organizational structures. Relating it to the scenario, Mr. Joe is a director of logistics and procurement at NMPC. So in his contract of service, NMPC has certain measures to exert control over the employment terms, key roles assigned to him and key deliverables that his office is supposed to meet up with, which could also have sanctions where he fails to deliver on those jobs. In terms of the contract for service, the test for Mr. Emmanuel, the only thing will be, there won't be organizational structure and control, but there could be key performance indicators where maybe a client gives him a contract to execute, but that will be solely based on his agreement and negotiations with the client he's dealing with per time. So it's not a one-off, whatever he deals with at the time, the particular client he's dealing with at the time, and then the terms of it or rules of engagement between him and that client at the time. Whereas for those who have employee-employer relationship, there are strict employment terms for each organization that must be followed where you are employed in that organization to work as an employee. Thank you very much, sir.
Beautiful answer. That's a beautiful distinction. There's nothing more to that. Control test, integration test, which is also known as organizational test.
Hello, sir. Did you hear me? Okay.
I can hear you very clearly. You answered correctly. Thank you very much, Lisa Judith. Wrapping up, let's move over to our tax for today. Let's move over to our tax for today. There are two tasks for today. First task is to examine critically the rights of employees in the private sector to go on strike in Nigeria. Question 2 is a discourse on the implementation of national minimum wage for workers in private sector. This is how it will be done. I'll give you 2 hours to answer this question. The time is 11 o'clock now. So by 12 o'clock, I expect the first tax to be out. And by 1 o'clock, I expect the second tax to be out. You are not answering it individually. You are answering it as a group. Your group will answer the question, compile it, and send to me. Let me appoint my class rep for the purpose of this task. Maria Tuebi will be in charge of the first tax. You compile the tax and send to my email or my WhatsApp, whichever one is convenient for you. And Deborah Uju, you compile the tax for question 2 and send to my WhatsApp or email, whichever is convenient for you. If you have any question, you drop it on my email, oriname.akeredolu@omaplex.com, or text me on WhatsApp. The number is provided. I see somebody's hand is up, or time will fail us to hear your question or comments. Just send me a WhatsApp message or via email, and I will respond appropriately. Remember, we are answering the question as a group. Deborah Uju will gather the tax for the second tax, and Maria Tuebi will gather the tax for the first tax and send it to me. Thank you very much. I wish you all a very productive day ahead.
Thank you, sir.
Thank you so much, Mr. Oriname, for that profound presentation. Very, very insightful.
Thank you, sir.
So I have a question. Can I ask my question?
I was speaking. Can you hear me?
Yes, I can.
I expected you to wait for me to finish before making your submission. It doesn't work that way. So thank you once again, Mr. Oriname, for a brilliant presentation. Just because of time, I will give you just 1 minute to drop your contributions. Please, over to you. Hurry up, please.
Sorry, sir. Sir, as regards the second task, are we to group it like, I don't understand the grouping, group 1 or group 2, because I'm in group 1 and the tax is the question is the second tax. So are we to, I don't know if I'm to be in group 2, I really don't understand the taxing, like how to go about it, if it could be clarified. So I'll do it properly.
Mr. Oriname, the question was for you, sir.
All right, for the purpose of this tax, I've mentioned it on the chat box. For the purpose of this tax, it's not how we are grouped during the course of this session. For the purpose of this tax, we will fall back to our initial group for this week. I think we have 7 or 8 groups this week. We'll fall back to that group. Are we all understanding me in this concept? We'll fall back to our initial group for this week. All tasks will be done by all groups. The 2 tasks will be done by group 1 and 2. The second task will be done by group 1 and 2. Tax 1 will be forwarded to me through your class rep, Maria Tuebi, and tax 2 will be forwarded to me through your class rep, Deborah Uju. Any further question on the tax? I believe no question.
Okay, thank you, Oriname, and thank you everyone for your active participation in today's session. We look forward to another engaging session during the week. So before, I expect that before 2 p.m. today, you'll be able to reach out to Mr. Oriname to send all the necessary requirements or tasks that was assigned to your various groups. Please ensure you meet up with the deadline. So before I end today's session, I just want to drop two words of wisdom and food for thought for you guys. So probably when you go through the various while you are going through your daily activities for the day, I just want you to just settle down and also reflect on this. I want to read for you guys. So there's a popular quote from the former president or prime minister from India, and he said, "Learn as if you will live forever. Live then live like you will die tomorrow." So I ensure that in your daily activities or as you go on with your daily life, try to ensure that you push to become more, you push to become exceptional, whatever you're doing. Try to push for excellence in whatever you're doing. And also, someone also made mention of something that also got me thinking while I was sleeping last night. And he said, when you change your thoughts, remember to also change your world. Now, the world doesn't wait for perfect people to actually move the world. The world wants people who can actually take little steps, and those little steps or those little actions will have the best, will probably have the biggest improvement or impact you want to see in our world today. So I wish you guys a wonderful and a productive day. Thank you once again for your active participation in today's session, and hope to see you guys tomorrow and throughout the week. Thank you.
Thank you, sir.
Thank you, sir.